Today we're going to go over this very important interpretation regarding cross-border transactions issued jointly by market participants and DMO of the CFTC. It concerns a firm called SCB Crypto, Susquehana Crypto, and it's a firm in the Bahamas that does prop trading of cryptocurrency, and they want to hire people in the US. And the question is, how would that be viewed by the CFTC? Would that make them US persons? And why is that important? Because if what they do would make them considered under our statute to be a foreign board of trade, then the people that they trade with are in the US, then that would require them to register. So prior to the great financial crisis, if you wanted to be located abroad and be able to trade with US customers, you would have to get approval from the CFTC under Part 30 of the Commission's rules, and you would have to demonstrate that your way of doing business and your regulatory regime is comparable to what we have, and then you'd be able to access U.S. customers. So here's a Part 30 order for the Tokyo Financial Exchange that I worked on a long time ago. So under this order, because the regulatory regime in Tokyo was very similar to ours, they could have U.S. customers trading on their exchange. And Part 30 applies to foreign exchanges, so it would be comparable to what's considered a designated contract market in the U.S., like the Chicago Board of Trade, Chicago Mercantile Exchange, and that would be for futures and options. And then when the Great Financial Crisis happened and the CFTC got jurisdiction over swaps, there are swaps facilities that trading occurs, and they have a different look and feel to them, so they wouldn't exactly fit under the designated contract market regime. So they came up with this new category, Foreign Board of Trade. And this company, Susquehana, which does proprietary trading, wants to assure that if they were to hire people through a subsidiary in the US to help them do what they do in the Bahamas, that wouldn't subject them to US law, because that if you're considered a person located in the U.S. under 310C or a participant located in the U.S. under Part 30, then that could cause a problem for them. So under the Commission's rules, if you're located in the U.S. or your operations are in the U.S., you'd have to register if you're acting as a broker or as an exchange, but that's not required if you are a foreign person and you are located outside the US. And the only sort of wrinkle on that is if you are a foreign broker and you are allowing your clients to access US markets, you wouldn't have to necessarily register, but the trades that you're putting through for your clients would have to go through a US exchange and be cleared through a US FCM. So if we look at their letter, they're a proprietary crypto trading firm, and they are located they're not in the US, they're located in the Bahamas, their headquarters are there, their people are there, but they would like to hire some US people through a subsidiary, either programmers or quants or what have you, in the US, but their main operation is still in the Bahamas, and they want to know if they were to keep doing what they're doing in the Bahamas, but hire some support staff in the US, would that bring them under the CFTC's jurisdiction? So Part 30, which deals with the FCMs and futures and options exchanges, and Part 48, which deals with these foreign boards of trades, don't explicitly lay out what it means to be located in the United States. And they sort of use facts and circumstances tests, which lawyers love and clients hate. But they've said that they're going to look at where the entity is formed, its principal place of business, where the people who run the place are, sort of nerve center, the people that control it, direct the activities, that's where it is. So it's not just you can locate something abroad, but have your people here, who are the people making the decisions, where are they located, that type of thing. That's what you look at. So under an interpretive guidance that they issued in 2013, they said the principal place of business to generally include entities that are organized outside the U.S. but have a quote, center of direction, control, and coordination of their business activities in the U.S., i.e. their nerve center. And they gave several examples there, which you can check out in the 2013 guidance. But back to Susquehanna. So they're in the Bahamas, their CEO, COO, Chief Compliance Officer, they're all in the Bahamas, and they do crypto trading as a prop firm, a proprietary trading firm in the Bahamas. And there's two other firms that are kind of relevant for this. There's a U.S. firm that they say provides them with legal, compliance, and administrative services, but does not do the trading algorithms. So the trading occurs and the decisions are made in the Bahamas, and there is a firm in the U.S. that they're affiliated with that does the back office stuff. And the CFTC felt that that was not enough to consider it a U.S. person because the nerve center and all the decisions are occurring overseas. And they would also like to use this affiliate, SCB Advisors. So who's SCB Advisors? So SCB is in the Bahamas, and they want to open up SCB Advisors in the U.S., and they want to provide their trading tech to SCB Advisors. And because SCB Advisors will be doing stuff in the U.S., they want to know, does us providing this tech to these guys, which we control, does that make us a U.S. person? And the CFTC said that SCB is not a U.S. person for these purposes because they're still located in the Bahamas. All their people are in the Bahamas, and they're providing some tech to SCB Advisors, but that does not make SCB a U.S. person. By providing tech to these people and letting them trade in the U.S., that does not make them, SCB, a U.S. person. So SCB, Bahamas, SCB Advisors, technically Bahamas because they're organized there, but they have U.S. employees and they're going to be doing some trading in the U.S., but that does not make SCB a U.S. person. And since SCB is not a U.S. person, they wouldn't be required to register as a foreign board of trade under 48.3 or an FCM pursuant to CFTC Regulation 30.4A, because these proprietary firms do a lot of buying and selling. And if you look at it a certain way, somebody might decide that that is a foreign board of trade or an FCM, but what they're describing to the CFTC, according to the CFTC's two divisions, does not bring them within those definitions. And if they were, what would happen is that all those swaps that they were doing, those transactions, they would count towards what they call the de minimis. And if they crossed a certain threshold and traded more than a certain amount, then you would register as a swap dealer. And even if you didn't, if they were considered within the U.S. and they're doing swaps with U.S. people, those swaps would get reported. So there's documentation, reporting, record-keeping requirements for all that if you're in the U.S. And if you're not, you're not. So that is why they wanted this interpretation. And according to the CFTC, we're not talking about SCB Advisors, but SCB itself is not a person located in the U.S. It's not a participant. So Part 30 and Part 48 don't apply, and that they are considered a foreign located person for the purposes of 310C12, which provides that exemption for foreign located persons. So things to note, they're not opining on whether SCBA is a U.S. person because it's pretty clear that they are. They're just saying that SCB, which is the company that was in the Bahamas and is hiring people in the U.S. and hosting on U.S. servers, that would not make this entity a U.S. person. And what's the catch? So it was issued by these two divisions, market participants, my old boss, Tom Smith, and Raul from DMO. But as with any interpretations, it says this interpretation represents the position of the divisions and does not represent the views of the commission. And they can change their mind and withdraw it at any time. But for now, you're good. And why did I emphasize that it's just the opinion of the divisions and not the commission? Because if enforcement decides that this is not okay, and then they decide to bring a case and bring it to the commission, and the commission decides to take action, the fact that these two divisions issued this interp does not bind the commission because they are staff and the commission are their bosses. And this was issued by these two divisions, and generally enforcement defers to the operating divisions with regards to these interpretations. But with enforcement, sometimes you take your chances because the operating divisions tend to have a really good relationship with industry, and enforcement sort of has an on-off switch. So the operating divisions have a dial, you go up and down, and enforcement sort of has an on-off switch. Or if you want to think of it this way, the operating divisions sort of play catch with the industry, and enforcement plays dodgeball. So, but it is what it is. So that's my thoughts on this. So if you're wondering, my name's Pete. I'm a lawyer with 25 years experience. I started at a law firm doing securities and mergers and acquisitions. Then I worked as a federal regulator doing financial derivatives. And now I am still a lawyer and a consultant, and I just started this YouTube channel to share information with you guys. If you have a question about this, leave it below. If you have an idea for a future video or questions you have about some other topic dealing with finance, leave it below. And if you got some value out of this, just like and subscribe to the channel so that you'll see future videos. Thanks. Have a great day.